Welcome to Rebel Chaser. My name is Gail, and I have several clips for you tonight. The first one is with Judge Raquel West. She's having an interesting day. The second one is with Judge Webster, and the reason I included this is I just have a feeling this girl is going to FTA. Just the sense I get. The next one is with Judge Hahn in Washington, and Erin Winkles has this guy pegged and in her sights. So I'll let you see that one. The next one I'm actually going to cut in before that one starts. It's with Judge Michael Nelson in Texas, and it's the two moms. You know, the one where one of the moms used to be the dad, that one. And then the next one is with Judge Speedlin Gonzalez, also in Texas, and she's got kind of a similar kind of video. And this defendant is very concerned about the people around him because he is looking around, kind of looks a little paranoid. You'll understand why. And then the next one is with Judge Jeffers in Texas, and I just love her. I think she's so endearing and adorable, and I just love her. And then the next one is with, the last one actually, is with Judge Rosie Speedlin Gonzalez, again, also of Texas. The only thing is they didn't stream the first part of the hearing, but they cut out all the mundane stuff and left the best part. So I put that in too. I hope you guys like it, and I'll see you guys at the end.
Good morning, you're Tom Simpson. And Mr. Simpson was previously in court, entered a plea of guilty to the third-degree felony of deadly conduct discharging a firearm. I've received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. Yes, Your Honor, we have.
Are there any additions or corrections?
The only correction or addition I have is under misdemeanor history. There was an unverifiable from October 2022. Mr. Simpson tells me that was for no driver's license, no insurance.
Okay. What is the status of that UCW?
It was just recently.
So it's not the same offense date.
No, it's not, Your Honor.
That was actually after this.
Yes, Your Honor.
Which gives me some concern.
The court might recall I filed a motion to increase his bond at the beginning of this year based on that new misdemeanor unlawfully carrying a weapon case, which occurred right at about December, about the 29th of December.
Right.
And that was in conjunction with a unrelated, but at the scene of the murder that took place in City of Beaumont. He was stopped for carrying a firearm. And so I filed a motion to increase his bond. He's been incarcerated since the 2nd of January. I don't have a change to the PSI. I've reviewed it, but I do have a suggestion as to some type of treatment on it.
What's that?
I think he at least needs to go to ISF.
Cognitive.
Yes, Your Honor.
I completely agree.
Even though his criminal history is fairly limited, this involves shooting up an apartment building.
We all know how I feel about that.
Yes, Your Honor.
Judge, I understand the reason for requesting cognitive. My only request on behalf of Mr. Simpson would be that we hold it in abeyance and give him a shot at probation before we.
So, Mr. Simpson, I used to do that a lot, and I would say, I'm going to, send you to ISF if you mess up. But I have found, especially with younger people, that I'm not comfortable doing that because they all tend to mess up. I want you to have the tools before you get out of jail and get back on the streets and start living your life, hopefully correctly, and without guns and shooting, to have the tools to be able to be successful. And I'm not going to go along with an agreement like this unless I do something like that gives me some sense of, I guess, comfort that you're going to get some tools, some classes, some behavioral changes so that you can get out and do better. So, what's that?
With the PSI, I had 60-day PSI. It wasn't 30-day PSI.
I don't know what that even means.
PSI?
Yeah.
To check my background.
What about
It
it?
wasn't 30 days. It was 60.
Nobody told you it was going to be 30 days. It's never 30 days. It's always about 45 days or 60 days for them to get that done. So that doesn't have any bearing on what I intend to do to help you be successful. If anything, kind of the attitude that you're showing me gives me even more reason to believe that I should do what I'm thinking about doing. I mean, you're lucky you're not here for murder, right?
Mhm.
I mean, do you really understand that? Are you okay? Watch out. Hold on to him. Y'all need to pull up a chair. You want to have them sit down for a minute, and then we can finish? Yeah, go have a seat. We'll finish in a minute. Mr. Simpson, you feel all right? Come on up. Mr. Rojas. Okay, so Mr. Simpson, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings. You're on probation for a period of 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. One of those includes entering and successfully completing the cognitive track of the ISF program. So you'll do that. Once you get out, you'll be on probation, required to follow all of the rules. It's very important to me, and it should be very important to you, that you get your GED. It looks like you were awfully close to graduating, right? 11th grade. So a condition of your probation is that you get your GED, and I want, once you are released from ISF, I want you to start that process, or I'm ordering you to start that process within 30 days. You got to start taking those classes and getting that done. That'll help you be more successful in life. Okay. If you do everything that you're supposed to while you're on this probation, this is the biggest opportunity you're probably going to ever receive in your life, based on what the nature of your offense is and the fact that you're getting a probation anyway, right? So you won't have a criminal a conviction on your record. You won't be a convicted felon. If you violate any condition of probation, though, you're right back in here, convicted felon, and looking at going to prison for up to 10 years. Do you understand? It's important that you have absolutely, it's part of your probation, no contact or no communication at all with Charlene Jones. That means in person, obviously, but it also means through social media or sending messages through other people. You cannot be anywhere near 2726 13th Street in Port Arthur. Is that is that a house or is that an apartment complex? It's a house.
That appears to be a house. Yeah.
Okay. Don't even be on 13th Street. All right. Go around it if you have to get somewhere. And so you cannot, I know there's been an issue also with you smoking marijuana. Can't do that. If you test positive, it's a violation of your probation. Probation has the tools to help you. If you feel like you're having trouble, you need to ask them ahead of time. Don't get in trouble and then say, oh, now I need help, right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Probation will talk to you today so that you'll know what to do when you're released from ISF.
Your Honor, he's going to need to take care of that misdemeanor before they send him to ISF, right?
Yes, and so you'll have to get that taken. Y'all are planning on taking them down. It's set today down the hall. And so if you'll make sure there's somebody down there, Mr. Rojas, and if there isn't and you handle it, just make sure they put you on it so that you can get that taken care of as well as his attorney. All right, thanks.
All right, we are back on the record. Counsel, which case do you want to take up first?
Well, let's take up Hopper real quick, Judge.
Very well. We are on the record in 2023 TR 960, State of Kansas versus Ginger Kemper, with Paul E. Dean for the state and Richard Paul for the defendant, who also appears in person. Counsel, how does your client wish to proceed on this one count of no liability insurance?
Judge, after speaking with Mr. Dean and Ms. Hopper, she still is, Mr. Dean is still going to offer her diversion. She's going to have her paperwork sent in done by Monday. And we've both agreed to set this on the 26th of April to have all the paperwork finalized.
The contract's already been done. She just needs to sign it.
Yeah,
get
she just
the money
needs to sign it
paid,
and send it
be
in.
done with it. So,
Yeah.
All right, well, she told us September 26th. No, September 26th of 23, she failed to appear for her first appearance. Then she came in October 24th of 23 and had the matter set over to December 22nd, at which time she said she was going to need more time for diversion. So she's been working on diversion since October 24th of 23, and we've had 2, 3, 4, 5. That will be her 6th diversion hearing. Do you think she can definitely get it done by then?
Judge,
Well,
if she doesn't, Mr. Dean is going to make her ineligible for diversion, and she'll have to plead on that date. So,
and additionally, it just occurred to me while we were speaking, that diversion agreement is going to have a modification to it, and additional $150 of attorney fees are going to be assessed, because when you originally applied, you were doing that pro se and there weren't attorney fees involved with it. So that doesn't necessarily have to be paid on the 26th. You have a letter giving you instruction on what needs to be paid to get the case filed, but that will be an additional amount because those have been additional costs incurred by the county since this case began.
And she's had 2 failures to appear. She also had one on February 2nd. So are you sure, Mr. Dean, she'll be back if she doesn't have it paid?
Well, if she doesn't come back, it appears we know how to find her, and she'll continue to not have the ability to drive because her driving privileges will be suspended by the state.
Ms. Hopper, what town do you live in? I can't hear you. You're muted, please. Unmute.
Howard, Kansas.
Okay, well, you're not very far away, so make sure you get that turned in or be back here and don't skip out on me. Your bond is up to 2,000 cash or surety. Looks
I
like
will be there.
been increased, it's been started out 1,000 and it's been increased several times for failure to appear. So I'll continue your bond, your most recent active bond, with the added condition that you be back here. What date, Missy?
Your Honor, I'm asking for the April 26th, our very next court date. That's as far as I'm extending it.
I like that. April
And I'm
26th.
assuming 11, but Richard, I didn't know whether the 11 a.m. was something you wanted to do or if you wanted that at 10.
let's just do it at 10, since I'm always on the 10. Occasionally
so-
I'm on the 11, but
Miss Hopper, you better be diverted or be back here to deal with me April 26th at 10 a.m.
Yes, ma'am.
Additionally, Your Honor, you going through that recitation reminded me there's probably 2 warrant fees that'll be added, which I think those are $25 each. But
Okay. Someone behind you was waving. Who is that?
Just Lamont.
Who's Lamont?
He's my boyfriend.
And why is he waving?
I don't know. Waving at you. Waving at you, I guess.
He was waving at me.
I guess so.
And what's Lamont's last name?
Ziner.
Okay, so we have met up in court before, Lamont and I, right?
yes.
All right. Well, both of you stay out of trouble.
Yes, ma'am. We are.
And hopefully you'll be diverted and not have to see me. So,
Thank you.
all right. Thank you. We'll be in recess at this time.
All right. Bye-bye.
Bye-bye. Bye, Lamont.
Bye.
All right, so that brings me to
the guardianship of Haley Murphy and Chloe Murphy, cause number 23-4-00301-08. This is Ms. Winkle's motion.
Yes, it's my motion to compel, Your Honor. We've been here, I believe this is either the second or third time. It appears that Dad has joined this hearing, but I've received absolutely not one response of discovery, not one question answered. So I'd ask that we strike the pleadings and then set another review for 2 weeks down the line. And if not done by then, we default. This has been going on for, my apologies. This has been going on for almost 9 months, I believe. So I think it's appropriate. I've tried to give him as much time as I can, and I've never received anything.
Right. Who else do I have appearing on behalf on this matter? I see.
Gianna Harrington here, Your Honor. I'm the guardian.
Okay, thank you.
Donald
And
Lisa, I represent the mother, Shannon Murphy, who's also on the call.
Okay. And do I have the father present?
Yes, ma'am.
Okay. All right, so sir, at this point, you have failed to provide discovery and there are rules about that.
Yeah, I have it all filled out. I didn't make it.
Stop. So I reviewed the files and record, and this has been going on for some time. So I want to, I haven't been involved in it to this point. So I want to know what's going on.
What's going on?
Yeah, why
What do
you
mean? My kids were taken from us.
I'm sorry.
My kids were taken from us with no regard for anybody's knowledge. They were with my wife when they got taken.
Okay, that's not my issue. My issue is solely about discovery, providing.
I have it filled out. I have it all filled out. It's sitting here in front of me. I didn't make it in before court.
Okay. This has been going on for a long time. There are court rules that you must follow in regard to discovery. You're expected to follow those. So with that, Ms. Winkles, anything else?
I've been left in the dark with it.
No, Your Honor. Last time I spoke to the father, he cursed at me and hung up. I think this time it's appropriate to strike his pleadings.
Curse at her. I told her she told my kids, and that's it.
Unless you want to be held in contempt of court, stop. I am addressing Ms. Winkles.
Yep.
Ms. Winkles.
And this is, yes, and this is the first hearing I've seen father at for quite some time. So I think it's appropriate to strike his pleadings. Obviously, he can still testify to anything else that's not in those pleadings. Most of those pleadings are about financials and things of that nature. So I'd ask that we strike his, or that he strike his pleadings with regard to any of the interrogatory questions that I asked. Apologies.
All right, so based on the length of time that this has been going on, I am going to grant Ms. Winkle's request. This has been going on for some time. This information should have been provided a long time ago.
Bunch of horse shit.
And so with that, I will strike the pleadings. We'll have to do an order that's necessary to meet the clerk's needs for that purpose.
I don't even know what's going on. Imagine that.
So with that, Ms. Winkles, when did you want to set it over for purpose at this point as far as the default?
Yeah, let's give father another 2 weeks, and then we can do presentation on the same day.
Okay.
Whatever.
All right. So sir, at this point, you need to provide the requested information and documents. Let's see, we're on the 4th. He's dropped off. For the record, the father has signed off. So, but for the record, I will give him 2 weeks to, let's see, that would be till April 18. So by April 17, the document shall be provided. And if not, then on April 18th, a default will be granted.
Thank you, Your Honor.
All right. And on that same date, just do an order, a presentation.
Absolutely. Thank you, Your Honor.
Thank you. That concludes this matter.
All right. Thank you, Your Honor.
Thank you.
Well, first I have to thank Miss Kinsley for this very cute avatar that she made. Thank you, Karen. I thought I'd throw it in here because I thought it was really cute. This next video is with Judge Michael Nelson in Texas, and it's with the two moms. The one I did earlier of the two moms where one of the moms used to be the dad, and now the kids are very confused and getting bullied at school. Well, they're back. And they're going to be coming back, I think, more than once. So I am going to make these separate videos because the first one I did was in a group of videos like tonight's. So I'm going to pull that out, do it separately, and then do the added videos along with it because I have a feeling we're going to see them recurring. So I'll let you guys watch.
At this time, the court's going to go ahead and call Bell County Cause number 23 DFAM 342,033. This is in the 146th Judicial District Court of Bell County, Texas. And this is in the interest of Wright minor children. Non-custodial party is Aaron Wright. Custodial party is Tina M. Wright. And this matter is before the court on a written petition suit affecting parent-child relationship. Of course, note for the record that both parties have previously been noticed and served. Yeah, we were last here, it looks like on the 8th day of March. Okay. And I don't have the reset order or the temporary order in the court file at this time. I know I did appoint Ed Lyda, Ms. Schwartz, who is present this time. So I'll ask the state for an opening to tell the court what the state's requesting we do here today, and then I'll let Ed Lyda make an opening statement also for the two parties. As you well know by now, you've probably heard me say, I don't let non-attorneys make opening statements. They don't get it right. They make arguments or closing statements. I'll try to give testimony before they're under oath. So at this time, I'll let the lawyers tell me what they understand the issues to be. And then at the end of the hearing, if either you wish to give a closing statement or closing argument, you'll be allowed to do so. So at this time, I'll ask for the openings from the state and then the ad litem. Thank you.
Sorry, Your Honor. The temporary order was not drafted. I've just sent it out today. It appointed Ms. Schwartz, had a limited visitation between both parties, and the court kept the right to domicile children in Belton ISD. This case was set for pretrial today, but Ms. Tina Wright is asking for it to be brought before the court to hear testimony concerning visitation. It's my understanding that Ms. Tina Wright would like visits to be supervised going forward because of incidences that she's had concerns about. It's my understanding that Ms. Aaron Wright is not in agreement with that, and that I want to make sure the court knows that because the temporary order was not drafted timely, Ms. Schwartz has not really had time to do an investigation on either party, and that is the state's fault.
All right, folks. I know we were worried about her not being here, and I'm still worried about this kind of being a trial by ambush. If there were no motions before the court to modify the temporary order, and Ms. Aaron Wright was not informed that this was what this hearing was about, I got it again. We would need her permission to proceed, and because she's entitled to 3 days notice. Okay, that's just it. And I was having trouble with that before, and I'm definitely still having trouble with it. So obviously anybody has the right to ask the court for emergency circumstances, but unless it's a true emergency, then unless Ms. Wright wishes to go ahead and proceed at this time, I've got no choice other than set this out at least a minimum of 3 days before we can have a hearing on this. So at this time, I'll let me go ahead and hear what the ad litem wants to do here based on those circumstances. And then I'll hear from Ms. Wright to see if she wants to have her proper 3-day notice. Thank you.
Your Honor, part of the issue that I had was I didn't have contact information for both parties, and that wasn't something that was on the state. That was because that often happens in these cases. So our first hearing was going to need to be a reset regardless, because I believe some of the information was confidential. So the first time that I've talked to either party is today. I have heard two sides to every piece of the concerns, and as such, without more time for evidence finding, I really can't take a stance on this one, because I could see it either way, and I don't have the proof. I have some evidence of what happened, but that doesn't seem to be in dispute. So I'm sort of stuck today to know what would be the right thing. And I also haven't gotten the chance to speak to the children, which would definitely influence my recommendation.
All right, then, okay, these are not babies, so we're dealing with a 10-year-old and looks like one, they're both born in January, so I'm dealing with a 10-year-old and a 7-year-old. So, all right, Sarah and Wright, obviously, like I said, there's been a problem with notice in this matter, but everybody's entitled to at least 3-day notice. Are you ready to proceed to a hearing this time, ma'am? Would you like to have the 3 days that's required under the Texas rules of civil procedure, unless there's a waiver to such?
I mean, honestly, I would like to have the days because I'm supposed to get the girls.
You don't have to explain it or anything. All you gotta say is, with certain judge, I'd like those days. And guess what, man? By the rules, I gotta give them to you, and I will. Sorry, that's just the, that's the Texas rules of civil procedure, and we abide by those at all times. So, but I am gonna look at, based on, everybody seems to have a little angst on this one, and everybody seems to be a little worried about possible circumstances. So I'm looking at I'm looking at resetting this matter within the next 3 days. Obviously today is Thursday, so and on a 3-day notice, so weekends can count. So starting next week, Monday, Tuesday, or Wednesday, I'm looking at trying to have a hearing on this matter, and I'll let everybody get out their calendars and let's see what we can do. Okay.
Strangely, Your Honor, I'm available on Monday.
Wow.
I know, I'm concerned. As long as that's not a secret holiday, I'm available.
Well, we had a real holiday. There was an Easter holiday that some of us got, and some of us didn't on Monday. And then, of course, there was the eclipse day. That was a secret holiday for a lot of folks that were only in the path of the eclipse. I guess those 4 people out in El Paso and everybody, they just got messed over. So, yeah. So let's see, on Monday. Oh, tax day. Okay.
That's all it says for me too.
All right, I do have 2 hearings, but I do have 3 o'clock. I got a hearing that ends at 3 o'clock, and so I got 3 to 5 available on Monday for a special setting, and you're the only case I'll have. Will that work for you, Ms. Swartz?
That would work for me, Your Honor.
All right. All right. Ms. Aaron Wright, I'm looking at 3 p.m. On Monday for further temporary orders. Ms. Tina Wright, I'm looking at the same thing. I'll start with you, Ms. Aaron Wright. Any problems with that time frame? Zoom hearing special, and I'll do the code before we get in the next few minutes and get it out to you. So there's
but can I ask an unrelated question?
Okay, just a second. Let me see. Just a second. Let me give Miss Tina Wright. Miss Tina Wright, 3 o'clock on Monday.
I'll make it work.
All right. All right, Ms. Aaron Wright, what's your question?
As to what I know that the concern that Tina was bringing,
Okay,
is it possible to have a witness about it?
Ma'am, you're your own representative. You can bring in a witness, and that witness can testify. But again, ma'am, I gotta hold you to standard as if you went to UT Law, okay? You just can't, you have to present the witness in the fashion in accordance with the Texas Rules of Civil Procedure. And I know you're gonna get tired of me hearing you say that, but again, you just, anything you do with that witness, you gotta do it just like if you were a real attorney, ma'am, okay?
Sure. Do I need to get pre-notice about it?
No, not for a temporary hearing. And then,
Okay.
so if you have a witness you wish to bring, but be sure to tell your witness that the court does invoke what's called the rule. The witness will not be allowed to hear testimony in the main courtroom from other parties. Just what the only thing the court will that witness will be able to do is to testify and not listen in on the hearing. Okay.
Thank you.
All right. Now, Ms. Kennerite, you had something? Do you have anything else, ma'am?
No.
All right, Ms. Hubbard, we're doing this at 3 in the afternoon on Monday, all right?
Yes, sir.
All right, thank you, Ms. Schwartz. Thank you, Ms. Hubbard. Thank you both, Ms. Wrights. And I'll go ahead and do the Zoom code right now. And I'm going to get that out to my assistant. And of course, it'll go out to the state. And that Zoom code will be in the reset order. I'll tell you what, everybody hang around. I'm going to go ahead and make that, and I'm going to I'll give an oral rendition of what the Zoom code is, just to make sure everybody has it and it's not being lost in email or DocuSign. Okay, so everybody, I'm going off the record at this time, but everybody please hang around until I make that Zoom code. Thank you.
Thank you, Your Honor.
Well, let's get on the record in case number 382717 and 382718. In each of these cases, the defendant is Mr. Kevin Ryan Burns. Mr. Burns, can you hear us?
I can, Your Honor.
Have you consented? Have you given permission to your attorney, Mr. James Hunt, and this court to go forward with your proceeding via video conference, also known as the Zoom app?
Yes, Your Honor.
Please stand by. Can I get announcements from the attorneys and from probation for and on the record, please?
Jessica Thompson for the state of Texas.
James Hunt for defense.
Maria Martinez for probation.
Okay, and Mr. Burns, I need to swear you in. Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury should you lie to the court?
I do, Your Honor.
Thank you very much. You may put your hand down. Mr. Burns, you were placed on probation out of this court probably about the time this court was established over 10 years ago. And on that day, you submitted an application to be placed on probation for 2 separate cases: a resisting arrest and search and an assault case. And the court granted your request to place you on probation instead of, in lieu of, you spending time at the Bexar County Jail for the offenses for which you were charged. The understanding from the court was that you were going to follow the judge's orders. At that time, it was Judge Monica Gonzalez, and that you were going to be compliant with the conditions of probation. I am confident that Judge Gonzalez warned you, admonished you, and said to you that if you came back to the court because the state filed a motion to revoke your probation, wherein they were alleging that you were not being compliant and that you were not following court orders, and after a hearing during which the judge hears from you, from the state, from probation, and your lawyer, if the court finds that you have indeed violated the order or the orders in this case and your conditions of probation, then, Mr. Burns, you could serve the full range of punishment for each of these offenses. For the assault, that's up to 1 year at the Bexar County Jail and up to a $4,000 fine, and you could lose your Second Amendment right to have guns, firearms, and ammunition. And for the resisting arrest, my documentation shows that's the same range of punishment short of your Second Amendment right not being taken. So you were looking at 2 years at the Bexar County Jail and up to an $8,000 amount in fines. Mr. Burns, I'm here to remind you that that is still the range of punishment. Do you understand why you're here today?
I do, Your Honor.
And do you understand the possible ramifications of this hearing today?
I do, Your Honor.
Thank you very much, Mr. Burns. Please stand by. Ms. Thompson is the prosecutor for Bexar County and the attorney for the state of Texas. Why are we here today? You can start with the 17 case and then tell me about the 18 case.
In Bexar County, Texas, the defendant, Kevin Ryan Burns, did then and there fail to report to the supervision officer in person and or by mail for the months of February, March, and April 2013 in violation of condition number 5.
Is that the only one you're going on in case number 382717?
Yes, Your Honor.
And which violation is the state proceeding on in the second case, 382718?
Violation number 5, Your Honor. In Bexar County, Texas, the defendant, Kevin Ryan Burns, did that and there failed to report to the supervision officer in person and or by mail for the months of February, March, and April 2013 in violation of condition number 5.
Okay. So Mr. Burns, I'm going to pivot to you now. The state is alleging that in your in your assault case, 382717, they're stating you failed to report to adult probation for the months of February, March, and April of 2013 in violation of condition number 5. Is that true or not true?
That would be true.
Okay. And then the state alleges in the second case, 382718, that you violated condition number 5 as well, and that you failed to report in that case for the months of February, March, April of the year 2013 in violation of condition number 5. Is that true or not true?
That would also be true, Your Honor.
Thank you, Mr. Burns. Please stand by. State, we have a true plea from the defendant for each violation. Violation number 5 in case number 382717 as pled by the state, and violation number 5 in case number 382718 in violation of condition number 5. We have a true plea as well. State, how do you want to proceed in each case?
The state recommends to revoke the defendant's probation and to impose to 180 days in Bexar County Jail.
In each case?
Correct, Your Honor.
Okay. Let's see what probation has to say. Officer Martinez, can you give the court the recommendation from adult probation in each case? And can you, I think these cases ran concurrent. So if you could just give me one recommendation as to whether Mr. Burns was compliant, and if he was, to what extent, or not compliant, to what extent in each case.
Yes, Your Honor. Probation is recommending revocation due to the fact that this case is 11 years old. During his time on probation from February 2012 to January of 2013, Mr. Burns was reporting. He stopped reporting, and that was the last time we saw him, was in January of 2013. His case expired in June of 2013. During his time on probation, he did no community service hours. He did not complete BIP. He had one drug test that was negative in May of 2012, and he has 22 days of credit in jail.
On each case?
Yes, Your Honor.
Okay. Mr. Hunt, the court will hear from you next.
Your Honor, I understand the complications of a probationer with a case like this. Mr. Burns is not the same person that was placed on probation 11 years ago. I would tell the court he's not been in trouble. He has been an active citizen. He's trained himself in the art of tattoo artistry. And I would request that I could either question him or let him address the court. I believe it'd be more efficient to have him address the court as to who he is now and what was going on with him at that time, if the court would allow.
Sure, Mr. Burns, I'm all ears.
Thank you, Your Honor. So I received my charges back when I was in my 20s and I was in a pretty toxic relationship. At that time, I had found illegal pornography of child pornography, bestiality on my home computer that my fiance had downloaded and saved. That's what initially caused the assault. I myself am a survivor of childhood sexual abuse. So when I found that material on our home computer, I obviously didn't handle it well, or the fact that I was betrothed to somebody that evoked the same evil that I had to live through. Upon my release, I had went through the probation period as long as I did. The reasons that I did stop failing to report is because I committed suicide. I am a veteran of the United States Army. I have an honorable discharge. But due to me being in the military, when I was revived from that suicide, I was taken to BAMC, that's Brooks Army Medical Center Hospital for inpatient program. The inpatient program runs about 6 weeks. Upon release, I was re-entered yet again after a second suicide only days after my release. So those two back-to-back inpatient programming, those equate for the 3 months of me not reporting. Afterwards, well, during my time during those inpatients, I was diagnosed with PTSD, borderline personality disorder, major depression disorder, and social anxiety disorder. I have gone through therapy. I admit that I was more focused on keeping myself alive than, coming back and facing something that I have pushed out of my psyche, being that it was so triggering and traumatic. Since then, like I said, I have gone through therapy. I have built my career as a tattoo artist. I have been paying my taxes. I've even gone through the process of changing my name as well as my gender, as I am transgender. And I have none of this popped up on my while going through getting my Texas state ID in 2022 or 3, as well as having my new name registered with my social security number. Otherwise, I would have taken care of this. I did not know I had a warrant. I have a lot of trauma that I have been focused on, healing. I still have more to go. I'm willing to, do whatever the court finds I should do in this case.
Mr. Burns, where do you live?
I'm currently at my mother's in Live Oak.
There an address, sir?
Yes, Your Honor. It's 12510 Prickle Pear Drive, and that would be Live Oak, Texas 78233.
And you say you're a tattoo artist. Where do you work?
I currently am not in a studio as at the moment. I'm currently I was looking into studios.
Were you in a studio before?
Yes, I was.
Where?
Sorry. That would be in California.
How long have you been back in town?
I came back this time in January. Before that, and then I was in California for 6 months. My father's in California. I've been bouncing back and forth between California and Texas.
How's your health?
Um, not too great. They think I have liver cancer. I have a couple more follow-ups to do at Northeast Methodist in Live Oak.
Who are you seeing for your PTSD and your other diagnosis?
That was all handled through BAMC.
Are you on any medication?
No, Your Honor, I am currently not on any medication.
So when I hear your attorney say that you've been trying to take care of yourself, you really haven't. Because you'd be on medication. And if they thought you had liver cancer, you would be on some medication, Mr. Burns. I really want to believe you. I really want to show you some grace. And you had me going there, and then I start to ask some questions, and I'm starting to discover you're transient, you're homeless, you're staying with your mom, you go between here and California pretty frequently, and you're not taking care of your health. Am I wrong?
No, Your Honor, you're not, but I don't have any health insurance currently. I'm going through to get my VA benefits. But that's a process in itself. But I have the documentation for that. As far as the transients, I mean, I'm staying with my mother currently. I came out here because my brother committed suicide. Otherwise, I would probably still be in California, honestly.
Mr. Burns, let me ask you a question.
Yes, Your Honor.
You're an adult survivor of some very profound trauma. Trauma keeps popping up in your life. Let me ask you this.
Yes.
Were your perpetrators ever brought to justice that you're aware of?
No, Your Honor. And
how does that make you feel?
I guess it makes me feel unimportant.
So you had a victim in this assault case. And I'm here to ensure that justice is done. And in any other school of training and thought, they would say to me, Judge, do not allow the defendants to turn this around and make themselves the victims and make the victim the perpetrator. And you did that. You turned this around and you said, I struck him or her because I found this child porn and I found this and it triggered me. Almost with some indignant tone to it, like they deserved it and I got the raw end of the deal because I'm really the victim. That's what I heard from you, Mr. Burns. I'm truly sorry that you have gone through what you're going through. To express my gratitude for you serving in the military. Your journey is not an easy one. I'm going to follow the recommendation of the state. And I truly hope that you take that gift and go take care of yourself. You did not do what you were ordered to do. You ran. You've been on the run. I don't know why a warrant was not picked up on a background check for you, given the processes that you need to go through to get a name change and a gender marker change. But you can run, but you can't hide, and it eventually caught up to you. I'm going to accept the defendant's true pleas for violation of condition number 5 and 382717 and violation in condition number 5 and 382718. The court is granting the state's motion to revoke Mr. Burns' probation in case number 382717 and 382718. And the court is going to adjudicate Mr. Burns guilty of the assault, bodily injury, married, alleged to have occurred on the 21st day of January of 2012. And this court is finding him guilty of the resisting arrest. I'm sorry, is it Mr. Burns or is it Miss Burns?
It's Miss Wilson.
Miss Wolfson, AKA, what's your first name, Miss Wolfson?
It's Lilith Amalia Wilson. That's
Lilith
L
Amalia Wilson. Lilith Amalia Wilson.
Wilson, Wilson.
Okay, I'm going to include that in your court records. Okay.
Thank you, Your Honor.
And Miss Wilson, I'm going to find you guilty of the resisting arrest and search in case number 382718. The sentence of Miss Wilson will run concurrently, and the court will follow the recommendation of the state, which is sentencing Miss Wilson to 180 days at the Bexar County Jail, in each case to run concurrently. There will be no fine. Miss Wilson is ordered to pay court costs, and the court orders that Miss Wilson get 22 days credit in each case, and her time and money will run concurrent. That takes care of the court costs. In the assault case, Miss Wilson, the court is issuing the affirmative finding of family violence. That's an order that will be issued immediately following this proceeding that is going to prohibit you from possessing, purchasing, owning, or using a firearm, a gun, and ammunition indefinitely. Miss Wilson, do you have access to or do you own any firearms, any guns, or any ammunition?
I do not.
Upon your release from custody, Miss Wilson, you cannot live anywhere, stay anywhere, or visit any location where firearms, guns, or ammunition can be found. Upon your release from custody, you cannot be a driver or a passenger in any motor vehicle in which firearms, guns, or ammunition will be found. And if you choose to go hunting, you cannot use a firearm, a gun, or ammunition to hunt with. That is the ruling of the court. Again, the ruling is going to run concurrent in each case. So good luck to you, Miss Wilson. And is there anything else, Mr. Hunt or Miss Thompson?
Nothing further from the state, Your Honor.
May I speak with my client in a breakout room, please?
Absolutely, Mr. Hunt. Can someone help James get into a breakout room with Miss Wilson, and then you're excused from the breakout room? I'm going to go fill out her paperwork and I'll be back for the next proceeding. Everyone is excused.
Laquana Williams. Miss Williams, same thing. You're here on the Class A misdemeanor assault. This one is also weird. This your ex-boyfriend?
Yes, ma'am.
But y'all live in the same apartment complex?
Yes, ma'am.
How far away are these apartments, madam?
From the jail?
No, how far away are y'all's apartments?
Oh, I'm on the top floor and he's like on the bottom. So it's pretty far.
Like in the same building or different buildings?
Yes, ma'am.
So is it, you know what the 100-meter dash is? Is it more than 100 meters? Is it?
Yes, ma'am, more than 100 meters.
Okay. He's requesting an EPO, which means I would render you homeless. You understand that?
Wait, which would say what?
He is requesting that I issue an emergency protection order because he says he's in fear of you and you won't stay away from him, which means I would have to remove you from your house. Do you understand that?
Yes, Your Honor. But this is somebody that is jealous of my new boyfriend that has been targeting me, harassing me, and really toiling with me and playing with my freedom and my life. I am a boss at a very good job. I don't bother people. I'm not this, what's on paper. They would not take pictures of my head.
Let me tell you what this says, just so you're aware before you meet with this.
Thank you.
This says he was sitting minding his own business and you approached him. That's what this says. And then they provided video of that. And that's what they showed the officer. You understand that?
Yes, Your Honor.
So here's what I'm gonna do. My turn to talk. Since y'all can't figure out how to argue and you have to get the police involved and the judge involved, I'm not gonna render you homeless, mama. So I'm going to remove the emergency protection order, but I need you to stay away from this man.
Yes, ma'am. Yes, ma'am, Your Honor.
If he's sitting in the common area minding his business, I need you to walk the other way, mama.
Yes, ma'am. Yes, Your Honor.
Okay, don't
Yes, Your
start
Honor.
none, won't be none.
Yes, Your Honor.
Ain't that what we used to say on the playground?
Yes, Your Honor.
So I need you to go the other way.
Yes, Your Honor. You have my word.
Y'all broke up, stop arguing, and move on.
Exactly.
Not sufficient at sea, right?
Amen.
We just get us a new partner and move on.
And I did.
Okay, so
And it became a problem.
if you see him, don't start. Just, I don't know who that is. I'm moving on. Okay.
Yes, ma'am. Yes,
But
Your
I
Honor.
know I just got divorced this year in the last few months. I know. They
Congratulations.
know how to push your buttons. Thank you for the congratulations. Most people say, I'm
Congratulations.
sorry. I'm like, no, it's a good thing.
It's a great thing. It's a great thing to be
You
free.
get to start fresh without all that drama. Right?
Amen.
So I just
Amen.
need you. I'm not gonna render you homeless, but I need you to work with me. Don't come back here next week because this man saying you arguing with him.
Your Honor, you have my word, never.
Okay.
I have too much going for myself. God has been too good to me.
Okay, because then you get me in trouble because I've denied his request for an EPO and then you back fussing with him in the comment.
No, Your Honor. No, Your Honor. This is it.
All right. So I've removed the EPO. I won't render you homeless, but what I'm saying is you have a no contact order and a 100-yard stay away from him. You see him, you got to stay 100 yards away. And this is your protection than anything. Because I know women can be mouthy, men can be mouthy in a breakup. I'm not going to render you homeless, but y'all need to stay apart. Okay?
Yes, Your Honor.
All right. That bond's been set at $5,000. Are you requesting that I appoint you an attorney this morning to help you with this case?
Yes, please, Your Honor.
All right. Now you got other issues. This says you are also on probation. You do understand that once you make bond on this case, the probation department's going to issue another warrant because you picked up this case. Do you understand that? So in about 2 weeks, you're going to have another warrant be issued against you, and you need to be ready for that.
But Your Honor, I'm completed with probation. My probation was only a 2-year probation. That was already over almost another 2 years. That's from the 2 year that I had it.
No, this is not saying that you completed it, Mama. When were you supposed to have completed it?
It would have been almost a year and a half, 2 years ago.
Okay, now, clearly you do not know what's going on, so let me share it with you. I'm so sorry. This says that they entered a bond forfeiture warrant a year ago, April 19, 2023, and that warrant is still active. Were you aware of that?
No, ma'am.
Right, so you've got a warrant for the probation case already. Yes, that's what this says. So it says there's a possible, she's trying to verify. She says there's a possible existing hold for an active warrant on a motion to revoke your probation. It looks like you were on a felony DWI that was reduced to a misdemeanor. Is that what happened?
Yes, ma'am. Yes, Your Honor.
All right, so.
In Judge Brown's court.
In Judge Brown. He's a very good judge. You know, he's
Yes, he was very blessed. I was very blessed.
Who is your attorney on that case, madam?
It was supposed to be,
Who placed you on probation?
Judge Brown, and
who was your attorney?
the attorney was,
Were they hired or appointed?
he was appointed.
Oh, he was appointed. Okay, that's why I don't know who his name. They don't have a name listed, so I can't tell you who to call. But
Machado. Machado.
Oh, Albert.
Albert Machado. Yes, ma'am. Yes, sir.
Practiced with him for more than 20 years before I took this job. So you want to give Machado a call this morning. That should be your first call, because this bond's been set low, right? It's only going to take you 5 to 10% of the bond amount to be released on this case. So that's $250 to $500. But you need to resolve that probation warrant, which is a no bond, which means you'll sit in jail for the next 7 days until you have a hearing in front of Judge Brown. So you need to call Albert Machado first thing this morning and say, hey, the judge let me know they think there's a possible probation warrant. I need you to take care of this. Tell me how I take care of it so I don't get held in jail for the next 7 days. Okay?
Okay. So I have another.
Does that make sense?
I have a hold on me.
Potentially, pretrial has put here that there is a possible pending motion to revoke warrant. That's what this says. That's why I'm telling you this. And if that's the case, then you can't be released. You can get this hold lifted on the misdemeanor, but you'll still have to resolve this motion to revoke probation warrant. So that's why I'm telling you, call Mr. Machado first thing, so you can have both things happening at the same time and you don't sit in jail for the next 7 days. Do you understand what I'm saying?
Yes, Your Honor.
All right. Now, I'll give you the same information I gave the previous young lady. If you believe that the alleged victim, the ex-boyfriend, will provide the victim input statement and say he's not in fear, does not feel threatened, and wants you released from jail, then we'll give you a personal bond on this case for free in the next 4 to 6 hours. It just doesn't sound like that's what's going to happen, because pretrial is saying that he's already saying he's afraid and he wants an emergency protection order. So I already denied the request for the emergency protection order, as we spoke about earlier. Okay.
Yes, Your Honor. Thank you.
All right. So just contact Mr. Machado, make bond on this case, stay 100 yards away from this man.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Do you have any other questions for me, madam?
No, Your Honor. Thank you so much.
You're very welcome. Take care of yourself, ma'am.
God bless you.
Thank you.
I hope he's at daycare.
And where does he sleep every night?
He sleeps. We pretty much go back and forth.
How are you going back and forth with the no contact order?
Through her dad.
Who gave her dad permission to do that between you two?
I was told from the lawyer relayed that information to me.
What lawyer was that?
Mr. Ramos.
Really? On a no contact order? Okay, that's your testimony?
That's just what I was told, that we are able to go through, especially because we have a son, go through him about picking him up and
yeah, we don't have that protocol. Number one. Number two, are you on paper with this child? Have you gone to child support court and established your paternity, and are you paying child support, or is she paying child support?
No, ma'am.
Okay.
I'm on a birth certificate.
All right. You haven't gone to court to establish your paternity. That birth certificate is just one of the items that you can use as proof to establish your paternity. That's it. Anything else, Mr. Ramos, of this particular witness?
No, Judge, only to offer that I did offer to Ms. Martinez and to Mr. Nunn in terms of to avoid it because of childcare issues. It was my understanding it would be okay for Ms. Martinez to leave.
Mr. Ramos, with her. I'm going to say this to you now.
Yes.
Only a judge can do that.
Okay.
Only a judge can steer away from this no contact order. And the no contact order is very clear. You've heard me read it to defendant after defendant after defendant. There is no third party exception unless the judge makes that exception. If you want to call your client next, you can, or anybody else, or are you passing the witness to Ms. Thompson?
I am.
Ms. Thompson, any questions of Mr. Nunn?
Yes, Your Honor. Good afternoon, Mr. Nunn.
How you doing?
Hi. You previously mentioned that that you have contact with Miss Francis' father with respect to your son. Has anyone or any other third party tried to reach out to you or contact you on behalf of the defendant?
No.
And when you filed the affidavit of non-prosecution, was it done voluntarily?
Yes, ma'am.
The affidavit of non-prosecution has no bearing on a hearing on bond conditions. Mr. Ramos brought it up. I let it slide. We don't talk about affidavits of non-prosecution. That goes to prosecution. This is not trial today, Ms. Thompson. Please go on to your next question.
And Mr. Nunn, why do you want the removal of the no contact order?
I don't feel in fear for my safety nor hers or my son. Like I said, we both share a son together. Before the no contact was even put in place, again, through the jail phone and all that, I've helped her. We both talked about wanting to fix this. And again, we're young. That's no excuse for what happened, but that we want to work on things and go about it the right way. So, and we won't be able to do that with her being over there. And I get it due to that's consequences. I understand, but still, it doesn't help. We both share a son, and again, I want to work on this with her, and that's what she also expressed to me as well. And I want to continue to do that, and like I said, go about it the right way.
Okay. Your Honor, the state, no further questions. State, pass on this witness.
Mr. Ramos, do you want to call anyone else?
No, ma'am.
Okay. Let me just say this. Doing it the right way, Mr. Nunn, does not mean you do it your way. There are orders in place, and we take these types of charges very seriously. Who called the law enforcement on that night? Who called law enforcement?
Nobody called law enforcement.
Well, somebody did because they showed. Go ahead.
If
She
if
went.
I
She
can
went.
interject, Miss Martinez actually went to the police substation to report a circumstance between the two of them. And then as she was giving information to the officers, Mr. Nunn showed up at the substation. At the time of the substation, police made a determination that for whatever reason, that Ms. Martinez was the aggressor. And as a result, I think they recommended that they either walk a warrant or arrested her at that location. But she went there to report an incident, and it resulted
so
in her arrest.
we don't know where this 2-year-old was at the time of the alleged incident, because I don't know. I don't know where that child was. No one
If
has
my memory
made.
is correct, I think it was with, I think the child was with her father or a family member.
Okay. All right. You want to do it the right way, then you're going to go to counseling before I allow any contact. You want to have contact, you're going to have it inside the office of a certified marriage and family therapist. That's how you do it the right way, Mr. Nunn. That's the only place I'm going to allow contact, Mr. Ramos, at this time.
Ms. Martinez has taken steps to seek counseling. She's been submitting
Okay, you're
updates.
testifying now, Mr. Ramos. So are you going to be a witness or are you going to be a lawyer?
No, Judge. As a lawyer, I just wanted to see what the best way to get these documentations in front of the court to see if they satisfy the court's requirement. And if they don't, she's happy
You
to
do it like
review
any
them.
other piece of evidence. You either submit a report and see if that satisfies the court. And if it doesn't, you subpoena the witness to come in and testify that professional has spent time with Mr. Nunn and Ms. Martinez in their office over 3 or 4 sessions and is comfortable recommending that they cohabitate and co-parent together. That's how you do it, Mr. Ramos.
Yes, ma'am. And just for clarity, are you allowing both Mr. Nunn and Ms. Martinez to get some counseling together only to that extent?
Only to that extent, until I have another professional coming into this into this courtroom to testify with their license in tow, saying, I've spent time, I've assessed the situation, and this is my recommendation. My recommendation is that they can have contact now. They can cohabitate. For now, this court is not happy with the way that this has transpired. No one had the authority to allow a third party to run in between Ms. Martinez and Mr. Nunn, but the court. No one. So that stops until I get a therapist in here to tell me otherwise.
And I apologize.
I'm not asking you for anything right now, Mr. Nunn. Your testimony is over.
Yes, ma'am.
They're not married. No one's gone into an attorney general's office to establish any type of parentage, paternity. And I'm not going to be complicit in generational trauma and creating a whole new generation of children becoming adults whose parents couldn't find a healthy way to interact with each other. You want to do it the right way, Mr. Nunn? You go get guidance with Ms. Martinez. That's the only place I'm going to allow for contact. And when that professional comes into this court to say, they're fine, Judge, then we will lift the no contact order. That no contact order is going to stay in place, and we're going to have one exception. When they're in the office of a licensed marriage and family therapist in a secure and protected environment. That's it, Mr. Ramos. That's the ruling of the court.
Yeah, I appreciate, Judge. In terms of logistically, can Ms. Martinez, in terms of coordinating which counselor they're going to pick and times and
I only
dates-
have jurisdiction over Ms. Martinez. So the order is, you want to get this no contact order lifted because this is her motion, then she needs to make the arrangements to go and find a therapist, a family therapist, to see her, and then give that therapist the information that the therapist needs to call Mr. Nunn to get him in and start couples therapy or make a referral out. Because I do believe that if she sees a therapist individually, then that individual therapist must refer out on family therapy because now it becomes a conflict. So that's my understanding of how that works.
Okay, Judge. All
Okay.
right, so, yes, ma'am. Anything else, Judge?
No? Anything else from you, Mr. Ramos?
No, Judge, I don't think so.
All right, then that concludes today's proceeding. I'll go right up the order and I'll come back for the next hearing. Everyone is excused.
Thank you all so very much for watching. And again, thank you, Miss Kinsley. I so appreciate you. Thank you for being my moderator. I really, really appreciate that too. And I'll see you all next time.